Hi, good afternoon, everybody. Thank you for joining. Um, David Korman is going to run this webinar based on the joint tenancy to avoid probate. David, I think mostly this would pertain to um, our parents or aging people that may most likely be pertaining to that, but it can also work for couples, etc. It's a neat topic. I just actually used Cormans to do a similar thing for my mom's property. So, a lot of us have done that already. Where you have spouse or you have kids, where you can share the value of the property for later years to come. So I'll hand over to David.
Okay, thanks, Sabiha. And yeah, I agree with your introduction. It's certainly something that becomes more in the forefront when we're dealing with the older generation. But the reality is, Sabiha, and everybody else that's watching or listening to this, we don't really know when we're going to die. We all expect we're going to live a long life and die, old age, and we try and plan our affairs accordingly. But the reality is, we just never know when our time is up. So I think it's an interesting discussion that you'll see. You'll look at it from your own point of view, your family's point of view, but also you should be looking at it from your client's point of view when they're buying properties and setting up their own affairs, because it's an issue that we discuss on every single purchase transaction when there's more than one party buying it, and sometimes even there's only one, but we find out, like what's their marital status, where are the funds coming from, how should title be taken. And really there's two ways for an individual to hold, or individuals, excuse me, to hold title, registered title to real estate. And so I'm just going to start just giving you that by way of introduction. They're either holding title as joint tenants or tenants in common. Okay. And first of all, the word tenancy that's in both terms has nothing to do with the concept of landlord and tenant. It's just a legal term. So it's joint tenants or tenants in common. It's got nothing to do with leases or landlord and tenant relationships. These are just defined legal terms. And the biggest difference with the way you hold title is really what happens upon the death of one party. So the simplest example, if a husband and wife own title together as joint tenants, when the first one dies, the title automatically passes to the survivor. By law, it automatically goes to the survivor. Okay, that's the right of having the right of survivorship by owning the property jointly. Okay, now if it was tenants in common, husband and wife both own the property registered as tenants in common instead of joint tenants, and then the first one passes away, the title of the deceased does not automatically go to their spouse. So husband and wife own it together. Everybody knows husbands always die before wives, so I'll use that example. So Mr. Smith passes away. Mr. Smith owned 50% as tenants in common. His 50% interest does not go to his wife. His 50% interest goes to his estate. And if he has a will, the will says who the beneficiaries of his estate are, who it goes to. If he doesn't have a will, there's a bunch of people that can make a claim on his estate to share, including his wife. His wife may be able to make a claim, but it doesn't automatically go to her. So it's really significant. The other difference, just so I don't forget to point it out, if you own title as joint tenants, it's not a percentage ownership. Like you each own the whole thing, but as joint tenants. So when one person dies, Mr. Smith dies, Mrs. Smith gets 100% of it. Okay. If you own title as tenants in common, then registered on title will be the percentage of your ownership. So it might be 50-50, it'd be registered as 50-50. It could be 90% and 10%. It could be 99.9% and 0.1%, which is something that we do a lot of times when we have to put someone on title, for example, a parent who's guaranteeing a mortgage for their children or something like that, and the lenders insist they go on title. So we might give them a 0.1% or a 1% interest or something like that. So they'd be registered as tenants in common. So before I go any further, I want to just get into the size, but so just keep that in mind: joint tenants versus tenants in common. So I'm going to skip through the introductory slides here. If you're not familiar with me or my firm or what we do, then you're talking to the wrong agents there. You're speaking to the wrong people. Speak to Sabiha. She'll tell you all about us. She can do a commercial for my firm better than I could. Speak to David Gorski, the star of the David and David on Real Estate podcast. We just recorded episode 88 on Monday. It'll probably be out by the beginning of next week. We've had some really interesting guests on with us the last few weeks. So if you're bored of listening to the two Davids talk, tune in to capture some of the guests that we've had. And just a couple episodes ago, Sabiha was on instead of David. So please, you got to tune into that one for sure. So look it up wherever you listen to a podcast, or you could go to the Korman's YouTube channel. You could watch it there and take a look at the table of contents, see what's of interest to you. Please send suggestions. We're always looking for suggestions for topics and for guests. So please reach out to David or to me and let us know and give us some feedback on that as well. All right, so let's talk about how we.
David,
Yeah.
can I quickly just put in, Abu has asked something which I think you just answered, but his message came in later, so I just wanted to be clarified. He says, what if the title of the primary residence is only on one of the spouse's name? Wouldn't that automatically go to the surviving spouse?
No, and that's a great question. And the answer is that it will not. Okay. If Mr. Smith owns the property himself and he dies, it doesn't go to anybody other than it goes to Mr. Smith's estate. So the property will have to be dealt with through the estate. So if there was a will, then the will would say who that property goes to. If there's no will, then someone would have to apply to the court to be appointed as the estate trustee, and then reach out to potential people that could have an interest in the estate. And then they'll have a battle over who gets what, which is a great argument for why everybody should have a will. Okay, so and part of what I want you to just keep in mind as I go through some of this stuff, what Sabiha mentioned right off the top, when people are thinking about, okay, I'm an elderly person, I'm reaching that point in my life, and maybe it's Mr. Smith and he owns title to his property by himself, his real estate, and he's thinking, well, maybe I should add my kids to the title and own it as joint tenants, one or more of my kids. And the reason that comes into play sometimes is to avoid probate tax, which is sort of the whole idea of this session that we're going to talk about. So let me just tell you what there isn't really something directly called probate tax. The term probate, which is the common term, isn't actually used anymore because years ago they changed it. So you're not actually applying to probate a will, but we use the term anyways, because the proper term is now applying to get a certificate of appointment of estate trustee. So all that means, and then you can see why it's easier to say we're applying to get probate than to say we're applying to get a certificate of appointment of estate trustee. It's just pretty wordy, but it's the same thing. So what happens is if you have a will, someone dies, you have to submit the will to the court office, and for them to basically approve it, rubber stamp it, put a certificate on it, and give it back to you. And when they give it back to you, what they're really confirming and certifying is not the contents of the will, because the judges don't care that much, but they're really appointing the person who is going to be the trustee or the executor of the will. Okay, so they give you back that certificate. So that's really why it's a certificate of appointment of the estate trustee, because that's the document that then gives that person the right to sign documents and deal with the assets of the estate. The problem from an estate planning point of view, when you make that application, at the time you submit it, which is just taking the original will, filing with the court with an application form that's signed by the trustee that's applying to become the estate trustee, you have to put a valuation on the estate as well. And you pay, the government charges a fee, which in essence is what we refer to as the tax or the estate tax, but it's really a fee that they charge, and it's based on the value of the estate. So, and it's roughly $15 for every $1,000 worth of assets. So if there was $1 million in the estate, you'd be paying roughly $15,000 to the government. Okay. So the question that comes up is there a way to avoid paying the government that $15,000 fee? And the answer is yes, sometimes there is. That's exactly what we're trying to do by using joint tenancy. Okay. So just to give you a simple example, Mr. Smith and Mr. Smith are, Mr. and Mrs. Smith are married, but Mr. Smith owns title by himself. He dies. His will says I leave everything to my wife. So the will has to be, and let's say the only thing in the estate is they own $1 million piece of real estate. So the application has to go in with his wife, who might be the trustee, saying I'm named in the will as the trustee, and the value of the estate is $1 million. So here, government, here's your $15,000. Please stamp this and give it back to me so that I can deal with the property. Okay. Now, if they held title as joint tenants, Mr. Smith dies, the title automatically goes to Mrs. Smith. She doesn't have to use the will to apply to the court. She doesn't have to give the will to the court office. She doesn't have to pay that fee. She gets title to the property, she just saved $15,000. So the same principle applies if it's an elderly person that wants to add their grown-up children to title, because they're the ones that would be inheriting under the will anyways. So instead of getting it to them through the will process and the probate process, we'll add them as joint tenants. When elderly Mr. Smith dies, his kids automatically get title to the property without going through the probate process. No $15,000 fee paid to the government. His kids are the surviving people. They already own title to the property. So that's a way to avoid those fees. Now, this doesn't apply only to real estate. Okay. Anything that is owned jointly has an automatic right of survivorship. So if people have a joint bank account, Mr. and Mrs. Smith have a joint bank account, Mr. Smith dies, Mrs. Smith doesn't have to do anything. She's the survivor. She can deal with the money that's in that bank account. We don't need the will in order for Mrs. Smith. We don't need the will to be probated in order for Mrs. Smith to access and use that money. So we don't pay a fee to the government based on whatever's in that bank account. Okay. The same thing applies for any other assets. If someone has assets where they can designate a beneficiary, for example, if someone had a stock portfolio and when they set that up with their investment advisor, they designate a beneficiary. So it could be Mr. Smith's stock portfolio, but he designated his wife as a beneficiary, or maybe he designated his adult children as a beneficiary. Upon his death, they are the beneficiary. We don't need the will to transfer the value of those stocks to the beneficiary. It's already happening because he designated a beneficiary. Okay, so that's an important thing for people to know for estate planning purposes. Whatever you can do to deal with assets and either have it as joint tenants or designate a beneficiary upon the death, you may not need the will in order to transfer the assets. So same thing applies to a life insurance policy. Okay, if Mr. Smith has a life insurance policy and it doesn't designate a beneficiary, then upon his death, let's say it's $1 million life insurance policy, upon his death, the insurance company will pay the $1 million to his estate. Okay, and because it's going to his estate, The will is needed. It's part of the assets of the estate, and the government will charge a $15,000 fee based on the value of that insurance policy. If, on the other hand, Mr. Smith took out the same life insurance policy and named his wife as the beneficiary or his children as the beneficiary, upon his death, the insurance company pays the beneficiaries that are named. It doesn't go to the estate. There's no fee payable to the government. Government's not involved. The will's not needed. Okay. So what part of the process of what people want to do for basic, simple estate planning purposes is to be able to deal with as many assets as possible outside of the will process. Okay. Now this works really good for married couples when the first one passes away. Okay. It's quite often, if their affairs are organized possible, when the first spouse passes away, that the will may never be needed. Okay. Because the spouses may have owned everything as joint tenants. Their real estate may have been joint. Their bank accounts were joint. They may have had other investments. They either joint investments or they designated a beneficiary. And if you do all that, when the first one dies, you may not have to use the will at all. And the will may never go to the court for the probate process. Okay, best example I can give you on this is my own dad, who passed away 13 years ago. Now, my dad was trying to be good that way, given that he's got a lawyer son. He's got two lawyer sons that were telling him he should do this stuff, to organize his affairs and my mom's affairs, to make sure things are held jointly and do all that. And we thought he did, like we thought he completely did. So when he passed away, the condo that they were living in went to my mom, and there was bank accounts went to my mom. We didn't have to use the will. And my father also had a whole bunch. He liked to invest in the stock market, and he was a menswear retailer, and he had a lot of connections. People come to the store and they say, investment advisor, oh, can you open up an account with us? And I'm buying suits from you. You'll be a customer. So he had different investment accounts with everybody. Name a bank, or a broker, and he seemed to have a small investment account. He couldn't say no to anybody. Anyways, we thought that was all dealt with. And after, about a year after he passed away, we were going through some papers and we found two statements. And one was Bank of Montreal, one was a TD statement. And we thought it was covered because we had other statements from this bank, but it turns out it was a separate account. So we found two accounts. He had these obscure mining stocks. He wasn't like an active trader, but he had these mining stocks that he held for decades in these accounts. So we look into it. I write to the banks and say, look, we didn't probate the will. Here's a copy of the will. My mom is the executor of the estate. She's the sole beneficiary of the estate. We haven't had to probate for anything else. Can we just transfer what's in the account to my mom without going through the probate process? So the first bank says, yeah, fine, no problem. Even though we have a threshold, but it's below the threshold, and we're going to allow you to do that. And they did it. The second bank, the guy calls me up. He says, I got good news and bad news. Our threshold for allowing things like this to happen is $100,000. So I said, that's great. So what's the bad news? He says, well, when you contacted us a couple of weeks ago, the value of that account, there was $90,000 in it. So I said, okay, so good. We meet the threshold. He says, yeah, but for some reason, there's been a run on those obscure mining stocks in the last couple of weeks. And the value of the stocks just went up to $108,000. We're over the threshold. So I said, well, that's sort of good news. Like the value just went up $18,000 in 2 weeks. He says, yeah, but you have to go through the probate process now, because that's the bank's policy. So you're gonna have to probate your dad's will, which we ended up doing just for that one investment account. So we had to pay, $1,500 or something, or my mom had to pay $1,500 to the government in order to get the $108,000 transferred to her. So, you live and learn. And one thing you should all know is a lot of the banks do have some sort of threshold for some things. So even though it was in one person's name, sometimes they will allow you to transfer without the will if you can give them enough evidence that there's no other reason to probate the will. You don't have to go through that process. So in this case, we had to pay $1,500, something like that. It got transferred to my mom. And the end of the story is she decided to take all her kids and her grandkids with this money, which she didn't even know she had, to Dominican for an all-inclusive week with everybody on my dad. So she spent the money, not all of it, but she spent a big chunk of it on us for a week. So you live and learn. Anyways, part of the process of what we want to go through is we want things to be held wherever we can, get it held jointly, get it held, designate beneficiaries wherever you can, so you can avoid paying the government, because better anybody in the family get it than the government. Okay. And I've already explained to you, what this next slide is, the difference in probate and letters of administration. It's the same thing. It's just the process of applying to court to get the will approved. And I also explained to you already, there isn't really the estate tax is really an estate administration tax, which is the fee that they charge. And it's based on whatever the value is in the estate. So whatever the assets are, if you can deal with the assets of the estate without needing the certified will as your authority for doing it, then you don't have to pay a fee to the government. It's just left out of the application process. So you only pay a fee based on the assets that you actually can't deal with without getting the certificate of appointment back as your authority to deal with it. Okay. And like I said before, it's roughly $15 for every $1,000 of assets. So you got to be mindful of what you're trying to save as well. Okay. So if it's $1 million estate, you're trying to save $15,000 if you can avoid it to the government. If it's a $2 million estate, you're trying to save $30,000. But you got to be mindful of, what are you really doing? Because in certain circumstances, does it make sense to transfer assets and create these joint tenancies or even a joint bank account, try to save some money? You got to weigh that against the loss of control that the true owner of those assets has by adding somebody to their title. And that's an important point to make, Sabiha, going back to your original point when we were dealing with elderly people. Like, I get asked this question all the time. Someone says, I own my condo. Should I add my kids to the title? And I go, but yeah, you're 60 years old. If you do that, and then you decide you want, and you own it mortgage free, but let's say you decide you want to go travel the world and you want to take out a small mortgage on your place. If you do that, you can't do that. You can't mortgage that property anymore unless you get the consent of your adult children. They might not like your plan. They might not like you spending their inheritance on your world travels, but you have to go get their consent if you want to mortgage your property. If you decide you don't want to live in that condo anymore and you want to sell it and move to Florida, or you want to sell it and buy a smaller place or whatever you want to do, you can't do that unless you get the consent of your children. So you lose control of dealing with your own assets. So you have to look at every case on a case-by-case basis. Sometimes it makes sense to do it. Sometimes it doesn't make sense to do it. Sometimes it makes sense to do it, but not yet. Maybe it's not the right thing to do when you're 60 years old, but maybe when you're 70 or 75 or 80, it's for sure the right thing to do. You want to add them on title. You have that relationship with your children. You're not concerned. You can trust them that they're going to do the right thing for you. So there's no black and white answer that's good for everybody. You have to assess each person's situation. I'm sure you're thinking about your own situation right now and thinking what would be good for your parents, what would be good for you, what your kids would want, etc. And the same thing for clients. So just keep that in mind, because those are the type of discussions that we have all the time when we're trying to assess whether it makes sense to add people as joint tenants. So first of all, nobody likes paying the government, right? So everybody would love to not pay the government. So at some point it makes sense, but if it's to transfer a $300,000 condo to add somebody and they're at a young age and they lose control of their property and they're trying to save, $1,000 in fees to the government, it may not make sense to do it, right? So we have to assess everybody's fact situation a little bit differently. So the process, as I mentioned before, of probating is really applying to get a certificate of appointment of estate trustee with a will. That's assuming that you have a will. Okay. Now, if you don't have a will, it's a similar process, but it's more difficult. You're applying to get a certificate of appointment of estate trustee without a will, which is a more difficult process. When you're applying with a will, you're saying, Mr. Smith died, Mr. Smith appointed his spouse, Mrs. Smith, as the estate trustee right in the will. So she's applying. A judge is not likely to turn that down. He's going to rubber stamp it unless someone shows up to court and say that Mrs. Smith doesn't have capacity or something like that, because someone could contest it. But normally, a judge is going to approve whoever the deceased appointed as their trustee to look after everything. If there was no will, it's open for anybody to apply to the court to become the trustee of the estate. So sometimes that can be contested. Sometimes it's very obvious who should apply. Sometimes more than one person wants to apply and it can be contested. So now the parties have to go to court. They have to have lawyers. They got to go convince a judge and have a little trial on it. I say little, but it's extremely expensive to try and figure out who should be appointed as the trustee of the estate. Okay, so now they're spending tens of thousands of dollars trying to figure that out. And then after that's figured out, if you have a will, the will is going to say who you're appointing as the trustee, but then the will goes on to say, when I die, this is who I want my assets to go to. You name whoever it should be and how much they should each get. So the will has to get followed. The trustee has to follow whatever the will says. Okay. If there is no will, the first step is going to court to get somebody appointed. And they might be fighting that out. And now they got somebody appointed. Now, phase two is let's fight about who gets what, who's entitled to share in the estate, because the person that died didn't tell us who they want to share in the estate. So everybody else in the world is allowed to apply to see if they should be entitled to share to some extent in the estate. So you're back in court spending tens of thousands of dollars. Everybody's got to lawyer up and argue and convince a judge why they should share in the estate. So it's quite a problem. And that's why everybody should have a will. It's much better to have a will. Doesn't matter what your assets are. Doesn't matter if you own nothing today. Okay, the will doesn't talk about what you own today. When you sign a will, the will basically says, whenever I die, whatever I happen to own on that day, after you pay off and whatever debts I might have, whatever's left, this is who I want it to go to. And when they die, there might be no assets, or there might be a whole bunch of assets. We don't know, because it doesn't matter what you own at the time you sign the will. It only matters what you happen to own at the time that you pass away. So it's always better for each of us to name who we want to look after our estate, and name who we want to share in our estate. So it's always a better argument to have a will than not have a will. And for the cost of doing a will versus the cost of applying to court when there is no estate trustee named in a will, and there's nobody, there's no will saying who gets in the assets, it's minuscule. Okay, the costs are really, really low to actually draft a will. So let's just talk again about how it affects your real estate transactions and my real estate transactions that we're all dealing with. So the big issue is, are people generally, when they're buying real estate or owning real estate, are they taking title as joint tenants or tenants in common, for the reasons I discussed at the beginning? And the basic difference, just to repeat myself, is what happens when you die. Okay, joint tenants, you don't have to do anything. Title automatically goes, by law, it goes to the survivor. Now, Mr. Smith dies, Mrs. Smith gets the property. Before Mrs. Smith actually deals with that property, if she was going to mortgage that property or sell that property, we do register a document on title, which is called a survivorship application. And all it states is Mr. and Mrs. Smith own the property together jointly. Mr. Smith died on May 4, 2023. Here's a copy of the death certificate. Therefore, Mrs. Smith is the sole survivor and title goes in her name alone. So we don't have to register that upon death, but we do have to register that on title just before we either mortgage the property or transfer the property to a third party. Okay, because if you're mortgaging it, it's Mrs. Smith by herself that's getting a mortgage. So that's just getting Mr. Smith's off title before we put a new mortgage on, or showing a third party that's buying the property that Mr. Smith's signature is no longer required because he died, but he held it as joint tenant. So Mrs. Smith has the authority to sell it on her own. And that's like I don't know what we charge. It's like $750 or something like that to do a survivorship application. It's really not a big deal or a complicated process to go through. But by law, upon death, Mrs. Smith owns the property. So if Mrs. Smith, she doesn't have to do anything. She can own it the next 10 years, 20 years, 30 years without doing anything. It's not until she's actually going to sell it or refinance it that we have to register the survivorship application. Okay. And usually we just do it as part of that transaction. Okay. So the value, when it's joint tenants, the value of the real estate, whether it's a $300,000 condo or it's $1 million house or a $10 million house, it's not part of the estate. And we don't have to pay that estate administration tax because they held it jointly. Okay. So depending on the value of the real estate, there could be a significant difference. So joint tenants, just a survivorship application eventually. Okay. If they didn't hold title together as joint tenants, then we have to go the probate route. We have to apply to get the probate in order to transfer the real estate. So we're either going, if there's a will, we're applying to get a certificate of appointment of the estate trustee with a will. If there's no will, we're going through the same thing, certificate of appointment of estate trustee without a will, and they're going to fight out who should be appointed. Okay. Now, when we do apply to court for this probate, it takes a lot of time. Okay. There's nothing in any legislation in the Succession Act, nothing that says the government, once you apply, the government has to respond and get the certificate back to you within 30 days, 60 days, 90 days, nothing. There's no time frame set. It's whenever the government gets around to do it, they give it back to you. So that makes a difference on your real estate transactions. Okay, whenever you're selling or dealing with a property, or maybe acting for a buyer who's buying from an estate, the first thing we want to know is, have they applied for the probate? Like, do they already have it in hand? Or is the transaction going to be conditional upon them getting the certificate of appointment? And when is that likely to be? And that's a really important consideration on a real estate transaction. So let's say we're on the sales side first. Okay, Mr. and Mrs. Smith owned, let's say it's Mr. Smith alone, right? If they owned it jointly, we don't have that issue. If Mr. Smith owned the property alone, so now the property has to be sold by the estate of Mr. Smith. Okay, so that's who the seller is. It's not Mr. Smith, it's the estate of Mr. Smith. That's who the seller is. So let's say Mrs. Smith, the surviving spouse, is the one named in the will as the trustee, and she would have been the beneficiary of the estate anyways. So she's the one that has to apply to the court to get appointed as the trustee in order to deal with the estate, including this real estate. Okay. Now, the law allows Mrs. Smith to sign a listing agreement with you. Okay, if you're going to sell this property, she can sign a listing agreement. She can actually sign an agreement of purchase and sale on behalf of the estate. She's not signing it in her name. She's signing it. It's the estate of Mr. Smith signed by Mrs. Smith, who's applying to become the estate trustee. Okay, so she can sign a listing agreement. You can market the property. She can actually sign an agreement of purchase and sale. What she can't do is close the transaction. You can't close the real estate transaction until she officially becomes appointed and gets that certificate of appointment back from the court office. So any sale transaction, agreement purchase and sale, is going to have to be conditional upon receiving the certificate of appointment. And we don't know exactly when they're going to get that. Government won't tell us. Okay. So whenever someone dies and there's going to be real estate involved to be liquidated, we want to get that process started as soon as possible. We want to get that application off the court office as soon as possible to get them working on it, get it in the pile so we can get it back at some point in time. Okay. So it's really important to know that. Okay. So they can sign the listing agreement, they can sign agreement purchase sale, but we can't close without their certificate of appointment. So if you're on the seller side, you want to make sure you get a clause in your agreement of purchase and sale, like this sample clause that I'm showing you here, that gives the seller the right to extend the completion date if necessary. So here, this clause just says that the seller has the right, upon giving at least 10 days notice to the buyer, to unilaterally extend the completion date by one or more times, not to exceed 90 days in total, in order to get the certificate of appointment of estate trustee. Now, this is subject to negotiation. Like, it might be more notice than 10 days, might be less notice than 10 days. Maybe it's only on one occasion. Maybe it's more than one occasion they can extend. Maybe it's 90 days. Maybe it's 120 days. Maybe it's only 30 days. That's all subject to negotiation. But if you're selling, you'd certainly want the right to extend for some period of time, whatever you can get, because we don't know exactly when you're going to get the certificate of appointment. So you want to have the right to extend, because otherwise, it comes closing date. If you don't have the certificate of appointment, you can't close. Deal falls apart. Now, if you get 90 days to extend and you still don't have the certificate at the end of the 90 days, again, the deal will be terminated unless the parties agree to amend and agree to extend for a further period of time. Okay. Now, I've said before, like, we have no idea when the courts are going to approve the certificate of appointment, and they'll never confirm when we're going to get it back. We have had some experience, though, when we've been able to contact the court and say, hey, we got a closing that's happening on May 4th. And, can you get our application to the top of the pile? And they'll never write back or answer a phone call or anything and confirm that they will. But sometimes magically we get the certificate of appointment just before the closing date. So we have had some success with that from time to time. Okay. And we've got a couple of times we've actually sent lawyers right down to the office to beg and plead to try and get it moved up, because we got a closing date and we don't have a right to extend the closing date anymore. And they'll never say we'll get it done. But we have had some success on a few occasions where magically all of a sudden we got the certificate of appointment available to us and allowed us to close. So I would never count on it, but you have to be aware that the clock starts running and it might run out on your agreement if you can't get it extended. And if you're on the buyer side, you have to have a buyer that's prepared to live with that. Buyers like to close and know when they're closing and get their moving truck in order and get all their plans going, and their decoration that they want to do in the property, et cetera, right? So this can really throw a wrench in their plans if they're planning to close on May 4th and all of a sudden, they're told, oh, so we don't have the certificate of appointment back. We have to extend for another 30 days or 60 days or 90 days or something. So there's an inconvenience involved. So you have to have the right buyer that's flexible, and you've got to have, the seller that understands the situation. But that's the process we have to go through, because we can't close the transaction without the certificate of appointment. Okay. So that's another reason why, if title was held by joint tenants, and if back to Sabiha's original example that we're dealing with a lot these days, we got an elderly parent. She's comfortable. I'm going to add my adult children as joint tenants. That way, there's two advantages. They all know that when I die, this property is going to be sold. But when I die, title automatically goes to them. They can sell the property whenever they want. They don't have to wait. They don't have to apply to get the certificate of appointment in order to sell the property. So they don't have to pay the fee to the government in order to get that certificate. So it saves them that money. And it also eliminates that timing issue because there's no delay, there's no uncertainty. Title is automatically theirs, and they can sell the property and agree to whatever closing date they want to that's convenient for them, and know that they'll be able to close because they're not waiting for anything. So it takes the uncertainty. So there's two good reasons why at some point in time it makes sense to go the joint tenancy route, okay, and not leave it to the certificate of appointment of estate trustee route. Saving money, you're not paying the government, and the timing factor, which is huge, and the uncertainty. Okay, now sometimes there's it does go to a judge, and they review the application, and sometimes they don't like the application, or there's an error in the application, or there's something, they've got questions, they're not sure who was given notice, and they got the right parties, and they get everybody, and does anybody else have an interest? So sometimes issues come up that could screw up, that makes it more than just a rubber stamping of the certificate of appointment process. So you got to be aware of that as well. But there's definitely a timing issue created when you have to get a certificate of appointment. So anyways, I think I've probably convinced all of you there's two good reasons to try and avoid going that route if you can. Okay, now sometimes you have no choice. Just going back to my parents as an example, when my dad passed away, everything goes to my mom, other than that one blip that we had and had to do that. Now, my mom being the second person, upon her death, we would have to probate her will based on whatever's in her estate, unless she gets to the point where she wants to add us on title to her real estate, or name us as beneficiaries on anything else that she might have. And everybody's situation is a little bit different. Sometimes they're comfortable doing it, sometimes they're not comfortable doing it. They lose some element of control. Okay, now whenever I talk about the joint tenancy issue and everything we've covered so far, I always want to talk a little bit about the process of wills and power of attorneys too. So in the next few minutes that I've got here, I'm just going to run through a few other slides that I added in here, just to give you a little bit more basics about what's involved with a will and power of attorneys as well. So the person that signs a will is the testator or testatrix. And I've already mentioned, the first thing they do is they decide who's going to look after the will. They're appointed as the trustee or executive of the will. And then you're saying who your beneficiaries are. But wills have to be signed properly in order to be valid as well. So you need two witnesses to the will, to the signing of the will, and they can't be people that are named as beneficiaries. Okay, so it's got to be two people that aren't named in the will as potential beneficiaries. So we have to know the will was signed properly by whoever's signing it, but it also has to be witnessed properly, and every page of the will has to be initialed, and it all has to be signed properly. And there's an affidavit of the witnesses that have to be submitted with the will when it goes to the court office. And if you don't have that, and all it is an affidavit saying, me and Sabiha were the two witnesses to Mr. Smith's signing of the will. We were both present together on May 4th. We watched him sign it. So we're just signing an affidavit, and that gets submitted with the will, because that's what shows the judge that the will was signed properly and witnessed properly. So it's just part of the process. So that's why I'm mentioning this to you, because I know some people say, oh, we're going to use a will kit. We saw a will kit online, or our clients are asking about it. And you got to be really careful, because we see people making mistakes constantly. And one is with the content of the will. Did it cover everything that it should be covering? Does it say what it's supposed to be saying? Do the assets go to the right people? That's obviously important. But also, wills could be invalid just because they weren't witnessed properly and signed properly. So, and people run into those problems all the time with wills too. So just be really careful about that. Okay, because that has to be submitted. Now, in terms of basic things that have to go into a will, I'm just going to run through these fairly quickly. The first thing that a will says is, I hereby revoke any prior wills that I may have signed. Now, it's almost impossible for any of us to sign a will, create our own will at some point in our life that's going to be valid and deal with all of our intentions as we move through life. It's almost impossible. So I always tell people, when you're doing a will, you can't think of, well, when I die 30 years from now, when I expect to die, or 50 years from now, this is what I want to happen. You can't really look at it that way. You have to look at it, if I die today, what do I do? Who gets what? Who looks after things? If my circumstances change 3 years from now, 5 years from now, 10 years from now, we'll change my will whenever it has to be changed, because it's really hard to make a perfect will. But as soon as you sign a new will, it automatically revokes any old wills. Okay. Then the next thing you do in a will is you appoint whoever's going to be the trustee of the will, the person to look after it. It's always a good idea to name an alternate. And then a will says, when I die, pay any taxes that I might have owing, any debts that I might have. And then you talk about, okay, who gets, after that's been paid, who gets whatever is left. And those are the beneficiaries of the estate. So you decide who's going to get it. Now, you might want to make a specific bequest to somebody. I want, this particular piece of real estate, or this particular portfolio of stocks to go to someone, or I want my car to go to somebody. You can make, or I want a certain amount to go to a charity, or you can make a specific bequest like that. And whatever's left over is usually called the residue of the estate. And it usually says, whatever's left over in the estate, this is who I want it to go to. And it might be something simple, like if I pass away, I want everything to go to my wife if she's alive. If she's not alive, I want it to go to all my children, divided equally amongst them, or something like that. So that's the residue of the estate. We also want to deal with other survival issues, because, okay, I want it to go to my wife if she dies before me. Then I want it to go to my children. Then we have to deal with the age of inheritance is one issue, because you can't inherit anything unless you're of legal age, which is 18 in Ontario. And 18 is generally pretty young for anybody to inherit things and just to get a check for what the value of the estate is. So I usually encourage people to go to a little bit higher age. But there's other issues too. Like in my example, like I've got 3 adult children. They all have children of their own. I've got grandchildren. So, my basic plan would be, I want everything to go to my 3 kids, divided equally amongst them. But if one of them, God forbid, passed away before me, I would want their share to go to their children, to my grandchildren, as opposed to going to my other kids, right? So I'd want it to go to them. So we got to be careful in how it's drafted to make sure things like that happen. Okay. Now, one of the best reasons, the best argument I could give to anybody to make a will, okay, is if you have children or you're expecting to have children, then you should make a will just to name guardians. So God forbid something happens to you and you've got minor kids, okay, and you want to name guardians. Who's going to look after them? Okay, so it's better for you as a parent to decide who should look after your kids if something happens to you, than for a judge to have to decide that. Now, even though a judge is always going to try and decide what's in the best interest of the children, who should they live with? Should it be the elderly grandparents? Should it be a sibling? Should it be the best friend? Like different people might apply and think that they're best suited to be the guardians. What a judge would really want to know is, what did the parents think? Who would the parents want to raise their children in their absence? But if you don't have a will and put that in a will, nobody knows. So everybody who thinks they should become the guardian can go to court and try and convince a judge why it should be them and not somebody else. Again, it's an extremely expensive process, and it's not a nice process for people to go through, because even people with the best of intentions, you might have the best friend, you might have a sibling, you might have parents all competing because they all think they're the ones that should look after the kids, and now they're arguing why the other ones aren't suitable to look after the kids, and it just breaks down a whole bunch of relationships. It's not a good process. So better for you, if you have a will, or if you're thinking about it for maybe you've got adult kids and now you've got grandkids too, you should encourage your adult kids to have a will. Encourage your clients to have wills, and just to name guardians. Now, they might change their mind a couple of years from now. I appointed so and so as a guardian. He doesn't live in Toronto anymore. He moved overseas. I want my kids to be raised here. I want to change it. I don't want it. So change it. Change your will. Okay. You change it whenever the circumstances change. It's not a big deal to change your will. It's way worse to not have a will. Okay. So get a will done. Encourage everybody you know to get your wills done. Now, most of the will, there's a lot of boilerplate provisions going in the will because we want to make sure we're giving broad powers to the trustees to deal with assets. We want to have a family law clause in because, like, just use my case, I intend that my children will inherit from me, and they might, and they're all married and they've all got great marriages, etc. But if one of my kids inherits from me, or they all inherit from me, and then a marriage breaks down, is it my intention that whatever they inherit will be part of their family property in a divorce proceeding that's going to get split 50-50? Or do I want whatever my children inherit from me to remain theirs and not become part of a divorce proceeding? So there is an opportunity in a will to deal with that, to state that in a will. So that's an important thing that has to be dealt with. Sometimes we deal with funeral instructions. I generally discourage people from doing it because a lot of times people really don't look at the will right away, and they're already deciding whether the family members are already making a decision. Are we cremating? Are we burying? Things like that. If you have strong feelings about that one way or the other, you can certainly put it in the will, but it's even more important to make sure your inner circle of people all know that and know how to deal with you, things like that. Anyways, I just want to point out some of the basic things that go into a will, and I want to tell you one more thing I want to tell you about a will, and another reason why you shouldn't use will kits. Part of our role as solicitors drafting a will is to assess the capacity of the person making the will. We have to make sure that we feel, and we make notes to the fact that whoever it is, the testator that's making the will, had understood English enough to understand it and understand their options. Were they of sound mind? Were they under the influence of anybody else? There's more litigation in the courts over estate matters and wills than there is any other type of litigation. And some of this comes out of that because sometimes we get asked all the time, well, I want to bring my elderly parent to you to redraft their will. Their English isn't that good. I'm not, they can still sign, but their understanding may not that good. But I want them to, transfer everything to me as joint tenants, and we'll redo the will and get everything to me and everything. And I said, well, wait a second, don't you have like 3 other siblings that should be sharing in the estate too? Why are we just transferring it to you? We have to ask these questions because sometimes it's one adult child that has a strong influence over somebody and bringing them to somebody to make a will. So part of a lawyer's role is to do an assessment of this and make sure they're not under influence when they're making a will. Make sure they understand what they're signing. They're making clear decisions. Okay, do they have the mental capacity in the first place just to sign a will, or is it too late? Okay, so these are all things that are really important. The other thing is, I don't know if some of you are aware, there's this concept of dual wills or having more than one will. And this is a legal estate planning thing that government allows you to do. And this really applies to people that have that own shares in private corporations. And a lot of you agents out there now have precs or will be getting precs, or you might have holding companies. So you own private shares. This doesn't apply if you own shares in a public stock exchange company. This is private holding companies or your prec, things like that. You own shares in that. So you're allowed to have 2 wills. One will is just to deal with the shares in these private holding corporations. We generally refer to that as the secondary will. The primary will deal with everything else. And the reason, whatever else the assets are, the reason you have the secondary will is that you're allowed to say, in my secondary will, when I die, whatever shares I own in these private corporations, I want to go to my wife. And if not my wife, then it goes to my kids or whatever it is. So you don't have to probate that will in order for the beneficiary to deal with it. So upon my death, if I had a secondary will, my wife can deal with my shares. She becomes the owner of those shares. She can deal with those private corporations. We don't have to, in the absence of that secondary will, my ownership interest in those shares become part of my overall estate. We have to put valuations on my holding company, your PREC if you have one, and you have to submit it as part of the application for probate. You have to pay the government the fee based on the value of those corporations. So by having two wills, you avoid having to pay the probate fees on the private corporations that you might own or you might own shares of. So we do two wills. First will is a primary will, and then you got a second. Primary will deals with everything like a normal will. The only difference is we state that this is my primary will, and I also have a secondary will that deals with shares and corporations. The secondary will says the same thing. This is my secondary will, but I also have a primary will. And the reason we make those statements in is because what I told you before, as soon as you sign a new will, it revokes the old will. So here we're signing two wills, but we're making it clear we're not revoking anything. There's two wills operating at the same time, a primary will and a secondary will, because they deal with different assets. So it's really important for those of you that have a PREC or a holding corporation or anybody you know that has a holding corporation that they should be talking to their lawyer. And obviously by lawyer, I mean me or someone in my office, about having dual wills and setting it up that way. Okay, so I don't want to take more time going through it. I had a couple other slides in here just talk about the benefits of having two wills, but I want to talk briefly for a couple minutes about power of attorneys. So wills, the will applies when you die. Okay, the will doesn't come into play at all until someone dies. While you're alive, it's important for you to have, you and everybody you know, to have power of attorneys in place. There's two different types of power of attorneys, and there's big difference. Power of attorney is state trustee. Power of attorney, you're dealing with things while somebody is alive. Someone dies, the power of attorneys are no longer valid. The will comes into play. And whoever was named as a power of attorney no longer has any authority to deal with anything. Whoever was named as the estate trustee is now in charge. Might be the same person, could be different people. Okay, so the power of attorney when you're alive. Now, there's two different kinds of power of attorney that most people should have. One is a power of attorney for property, which is the authority to sign documents on behalf of somebody else and deal with the assets that way. They have signing authority. The other form of power of attorney is the authority to deal with somebody's personal care. So if somebody is unable to provide instructions to a doctor on their own, whoever has the power of attorney can provide those instructions to a doctor. So it's always important whenever we do wills in our office, we always refer to it as a will package because we do a will and these two forms of power of attorney. I hope no one ever uses the power of attorney. I hope no one ever uses their will, but it's important to have these things because again, if you don't have them in place, somebody has to apply to the court to be appointed as for a power of attorney. Okay, the same way that someone would have to be appointed upon death to be appointed as the estate trustee. It's a much more expensive process than just having a lawyer draft up power of attorneys for property or personal care. Now, there's other different types of power of attorneys as well. Some you might be familiar with for property. It could be a general power of attorney, sometimes referred to as specific power of attorney. It could be a continuing power of attorney. And there's slight differences. So a general power of attorney usually says you have signing authority on my behalf at any time for any asset. It could be a specific power of attorney for, let's say someone is selling a particular property and they're not going to be around to sign documents for it. So they might grant somebody a power of attorney specific to the purpose of selling this piece of real estate and signing documents for this one piece of real estate. So it could be drafted that way. A continuing power of attorney general is similar to a general power of attorney, but it usually says that this can be, the difference is whether it can be used if someone is incapacitated. So sometimes the power of attorney, there might be a restriction on it that might say you can sign on my behalf, but only if I'm incapacitated. Or it could be something that can be used at any time, even if I'm incapacitated. I'm giving someone the authority. And they're very powerful documents. So a power of attorney with signing authority can sign any document, okay, if it's a general power of attorney. The only thing they can't sign on behalf of somebody else is a will. Nobody can sign a will by power of attorney. That has to be signed by the individual on their own. So I know it's a lot of information, as usual, in an hour or so. I'm happy to stick around for any questions. Please reach out privately to me at any time you got questions that the group may not want to hear. But Sabiha, I'll throw it back to you. I'm sure there might be some specific questions that people might have right now.
There are quite a few questions. So I'll start with a few were answered along the way because these questions started coming in at the beginning. But Abu has written, is that valid even for, okay, so this, I think we were talking about at that point, you should have joint tenancy, and he's asking, is that valid even for rental real estate, or probably investment, I guess, real estate investment purchased on a corporation name where the spouses are the sole joint directors of the corporation? So I'm guessing he's saying that there's two spouses, they own a numbered company together, they've purchased real estate together. Do they still need to have a separate joint tenancy on the ownership of that property above and
Yeah.
beyond?
Well, it sounds like might be mixing up a couple different things. Like if
Mm-hmm.
they own title through their corporation, if it's the corporation that's on title, upon death of one of the shareholders, nothing happens on title. The corporation still owns it. The issue is who owns the shares of that corporation. So if it was a husband and wife, they each own shares of the corporation, that's a situation where they should have a secondary will because they own private shares, so that the shares can be transferred from the deceased spouse to the surviving spouse without going through the probate process. But title ownership, registered owner, doesn't change by the death because it's the corporation that owns it, not the shareholders. So the corporation doesn't die, it still owns it. It's a question of who owns the shares of the corporation and how are we going to deal with that, and how are you going to transfer those shares from one party to another. Okay, so
Yeah.
always better
So
to have that dual will, so you don't have to pay a fee to the government on the value of the corporation, because the corporation owns the real estate. If it's $1 million real estate value, and if that's all that was in the corporation, then there'd be a fee to the government to $15,000 just to transfer that, because that's the only way you could do it. So that's why it's good to have that second will. Okay.
right. Yeah, and he had written that if there's no will in place, so that I think that answers both of those. I think this came in from Tara when you were talking about the trust agreements, and she says that trust isn't always about your own kids, but your kids' spouses as well,
Right.
which is very true. And influence
Right.
can come from other people. I think that was answered. Karen Vicky has written, what if one spouse dies after the sale, before the closing? So the agreement to purchase and sale is already firmed up, and the closing date hasn't come in, and one of the spouses passes away.
Yeah.
What happens to the
Yeah.
benefit coming
Yeah.
from the property?
That's a great question, Karen. And yeah, we can't close that transaction, unfortunately, without getting the certificate of appointment of a state trustee, because nobody has legal authority to sign on behalf of that spouse that just passed away. So the only way to get that authority is to go to court to get it. So if there's a will, you're going through the certificate of appointment of state trustee with the will. If there's no will, someone's going to apply to be appointed, and you can't close the transaction until you get that appointment.
Unless you have joint tenancy, which would
If it was
happen.
joint tenancy, that's not an issue.
Yeah. Heather has mentioned it may also create a capital gain scenario for that property for the added tenant.
Yeah, another great question. And let me just give you a scenario. So let's say, back to Sabiha's first time, we're dealing with an elderly person that wants to add their adult children to title to the property. Okay. So the way we do it usually, if the reason it's being done is purely to avoid the probate tax and to make the process simpler, we'll have them sign a trust agreement. and we just dealt with one the other day. We got an elderly lady, she's got 3 adult daughters. We're adding title. We're adding the 3 adult daughters to title. So what we do is we do a transfer from the lady herself to the lady and her 3 adult children, all as joint tenants. Okay. Now, when she dies, it automatically, the 3 kids who are automatically can deal with the property. So it solves that problem. So the question here, though, do they become owners of the property at the time the transfer of title to them? So now, and they're not living in that property. So then when the property gets sold, could there be capital gains tax on them? And I'm not a tax expert, but I'll tell you the way we sort of get around that. At the same time we do the transfer of title to them, we'll also have them sign a trust agreement saying simply, we're going on title as joint tenants purely to avoid paying probate tax and to avoid the probate process, because you're allowed to do that. It's nothing illegal about doing that. And what we're really doing is going on title so we can avoid that. But while we're on title, even though we're joint tenants, we're really holding the property in trust for our mother, and we'll deal with the property however my mother wants to deal with it. So if mom wants to sell the property, we'll sign and sell it. If mom wants to mortgage the property, we'll sign and mortgage the property, because we're really acting as trustees. So it's not really our property. Okay. And that sort of avoids the capital gains issue too. They're not living in it, but it's not really their property. They're just, it's still their mother's until she dies. Okay. Now, once she dies, then it becomes a question of fact, what are you doing with the property? Because if the 3 children that inherited it decide we're going to rent it out and keep the property and it becomes an investment property, then that could trigger capital gains eventually from the time of the death until they actually sold the property. But if all they're doing is just getting the property ready and marketing it and selling it, then there isn't capital gains involved. They're really just selling it on behalf of the estate, even though they don't need the estate to do it. They're selling it really on behalf of the estate, because it's really an inheritance, even though it was structured to avoid it looking like an inheritance, because we use the joint tenancy route. So that's sort of the answer to the question. We do the transfer of title and do a trust declaration or trust agreement as part of it as well, saying even though we're doing this as joint tenancy for specific purposes, the property is really being held in trust. It's still really the mom's property during her lifetime.
Right. Something Tara's put down is one obscure loophole, which is less and less likely these days, is first dealing exemption. I saved my clients $30,000 on their real estate this year. One executor was an accountant, and the real estate lawyer was not aware of this until I brought it to their attention.
Yeah. Excellent point, Tara. There's, the general rule is we got to, for transferring property, we got to deal with it, and we need the estate trustee appointed in order to deal with it. But there is an exemption for that, which is the property. It's called a first dealings exemption. If the property had never been dealt with from the time the owner acquired the property, and it was never previously transferred, which does happen occasionally, then there's a way to transfer the title even upon death without going the probate process. Okay. So when we're retained to deal in a situation like that, that's something we search title to see if the property ever been dealt with before. Because if it is a first dealing, we do. We just had that situation a couple months ago with a property in Welland. That was an investment property, a little apartment building, and no one really had looked at title, and we were going to and we had a will, and we were going to apply to we still had to probate the will because there was other assets that needed probating. But when we did our title search, we saw, hey, they bought this property like 40 years ago, and there's nothing on it. Nothing. They were the original owners. Nothing ever happened to this property. So we were able to use that first dealings exemption and save a lot of money, just like in Tara's example, because you didn't have to pay that fee to the government. We were able. It's a very obscure exemption that a lot of people don't know about, but it's something that we check. We always search title first before we we add the real estate value to the probate application.
Right. Something Abu had mentioned right in the beginning, and I'd kind of answered it, but it's, I think, a good question. So I think I'm going to just put it forward to everybody. Is can't find that question anymore. But what basically he was saying, yeah, he was saying that if they've already purchased the property in one of the spouse's names, can that transfer be done to a joint tenancy in the middle of the ownership or not?
Yes. Yes. Great. Great questions today. These are all good questions. Yes. Okay. A spouse can transfer it, can add their spouse to it. No land transfer tax payable for doing something like that, which is another consideration too. Like whenever you're adding someone to title, even as joint tenants, in some fact situations, there is some land transfer tax payable. Okay. So, and you got to weigh that, the cost of the land transfer tax versus the cost of saving the probate fee, which is much more expensive. So sometimes it's worth paying land transfer tax if it's payable in order to do it. So we have to look at every fact situation on their own. But it's really easy to if one spouse owns title and they want to add the other ones to become joint tenants, like that's a real easy process to go through. Okay.
David, I had a question here. Like in this process, like when you are trying to add the other spouse as a joint tenant, would the financial institution needs to be involved because there is a title transfer?
Yes. If there's a mortgage on title, most mortgages have a provision somewhere in the fine print that say you can't transfer or change the ownership of the property without the prior approval, written approval of the lender. Okay, it's in almost every mortgage that would be registered nowadays. So the good news is most of the time the lender's not going to say no, because let's just use Mr. and Mrs. Smith, for example. Mr. Smith owns title. Mr. Smith is the borrower on the mortgage. He's responsible for the mortgage. If he says, I want to add my wife to title, so TD Bank, will you please consent to it? The bank's not going to say no in most circumstances, because as soon as you add Mrs. Smith to title, she becomes responsible for the mortgage too. So it doesn't lessen the obligation of Mr. Smith, but now they got him on the hook, but they also have Mrs. Smith on the hook too. So it's not very often that a lender is ever going to say no to those circumstances. Now, if Mrs. Smith happened to have horrible credit rating or something, like it's conceivable they could say no, but it's really unlikely they're going to say no for something like that, because it's to them, it's just adding someone to the covenant. If you're on, even if you're added on and you're given, forget about joint tenancy. If you granted somebody a 1% interest, if a parent goes on title, because the bank insists that they're really a guarantor of the mortgage, the bank says, we want you on title. We say, fine, we're just going to give that parent a 1% interest on title. And we might even sign a declaration, a trust declaration, that they're going on for 1% for mortgage financing purposes, but they don't really hold that 1% in trust for their child that owns the other 99%. But just by going on title at any percentage ownership, that person is 100% responsible for the mortgage. So banks will usually consent because it's great. You're adding someone, great. I got somebody else to sue if I have to. Okay. Now, practical terms, if the mortgage goes in default, they're usually going to sell the property and get whatever they can out of the property. If there's a shortfall, they could come after Mr. Smith, but now they can also come after Mrs. Smith to collect on it.
Okay, and David, I asked this question already, and probably you kind of answered it. I was under the impression that if it's your matrimonial house, it doesn't really matter whether the title is on one person's name or two persons' name, like both the spouse's name or on a single spouse's name, and there would be no requirement of will or probate things. Is that understanding wrong?
Well, it depends what angle you're looking at it from. So if it's in Mr. Smith's name alone, he's the registered owner of the property. Now, if it's their matrimonial home, he can't sell that property or mortgage that property without getting his wife's consent. Okay, she's not an owner of the property, it's his, he owns it, but he can't deal with it without getting her consent. Okay, and that's her protection under the Family Law Act. And it's really a protection mostly for possession. You can't, a spouse can't be dispossessed of their own home or not know what's going on if it's the matrimonial home. This doesn't apply if it was an investment property or something. Okay, but if it's the matrimonial home, he can't sell it or mortgage it without her consent. Okay, now that doesn't mean she necessarily has an ownership interest in it. But if they have a marriage breakdown, the house isn't going to be sold without her knowing about it and without her family law lawyer being able to say, hey, you know, Mrs. Smith does have an ownership interest. She contributed to the purchase of it, or she contributed to the upkeep, or she paid the mortgage, or whatever they want to argue, and whatever percentage there might be. Okay, so in terms of ownership, it's different than right to live there and right to possession of the property and the right to not be dispossessed. So there's a couple different things in play there. Okay, but if Mr. Smith owns it and he dies, it doesn't go to Mrs. Smith unless he has a will that says it goes to Mrs. Smith.
All right, and in that case, again, like it has to go through the probate process of that $15,000 for 1 million.
Right.
Okay, got it. Yeah, probably I was mixing up between the family law protection and the probate process. Thank you.
Okay.
All right. Thank you, everyone. Great questions, great session, as usual, David. And we will be recording it and saving it on our YouTube channel if anybody wants to go back and review it. Thank you, everyone. Have a good evening
Okay.
and
Thanks,
afternoon.
Sabiha. Bye,
Bye-bye.
everybody.